Your Honor, today we will hear the case of Jackson Public School District versus Carter. My name is Kennedy Johnson, and I am representing the plaintiff, Tina Carter. The principal of Jackson High School wrongfully prevented the formation of a student group. This is a direct violation of the Equal Access Act of 1984, which states all schools that receive federal money and grants an offering of or as an opportunity for non-curriculum related student groups must provide equal access to all student groups regardless of the group's focus of interest. Because Jackson High School allows other non-curriculum extracurricular clubs and activities such as community service and religious clubs, it is a lawful right that the LGBTQI club be allowed a position as a school organization. The subject of the club should not be a concern, being that the Equal Access Act states that the school must provide equal access to all student groups regardless of the group's focus of interest. The club should be treated equivalent to all other extracurricular clubs, which means that the LGBTQI club should receive equal resources inclusive of a sponsor and location for meetings. Carter followed the proper chain of command to form a school club. However, she was still denied the opportunity to form her club. The principal has no legal reason why Carter was denied access to form the club. The principal denied the access to form the club based upon own personal biases on the LGBTQI community, which is a violation of the Equal Access Act. Previous cases, such as West Side School District versus Mergens, defends Carter's claim that the denial of the formation of a student group is unconstitutional. West Side School District versus Mergens established the Equal Access Act is supported by the First Amendment case solidified that as long as students have the choice to be exposed to the practices of a student group, then the club cannot be denied by the school. The Equal Access Act details students' freedom of speech and assembly. As an extracurricular club, the meetings are optional for students and outside of class time, which rules out the argument of the newly formed club causing any disruption. Based upon the Supreme Court's ruling in the previously mentioned case, the jury must vote in favor of Carter. The minute power of the Jackson Public School District does not overrule the Constitution or the Supreme Court's previous rulings. The formation of the LGBTQI club is protected by the Equal Access Act of 1984. No bias may prohibit the formation of this club. I rest my case.